So what is the objective actually today of our workshop here is really to explain you the new product safety rules that are set up by the new General Product Safety Regulation, and to help businesses to comply with these new rules. It takes into account also the several questions that we have received. So we tried to design it in a way that it should be really helpful for you and reply to the different questions that that businesses have been asking. And the PowerPoint as such indeed is supposed to be from us is to be exhaustive, and we are trying to covering all the aspects in sufficient detail. But of course, if you have still some questions when we are presenting or at the end, you can address them in the chat. So this you can do, and we will either address some of them if possible during the presentation or at the end. But I mean, I think that we will not be able to address all the questions. But anyway, even those we are not addressing, we will still keep them and improving and updating our guidance that we have on our website. So with that, we can start. So we will start with the objectives of this new regulation, and actually why we have I would say produced this new piece of new legislation. So actually, what was the problem? I mean, our reflection started already in 2020. We had actually in place a General Product Safety Directive, so we were not starting from nowhere, but we saw that even if this directive was very efficient, still there were a huge consumer detriment on the market, which was due to a lot of dangerous products that are still circulating on the European market. The European Commission did a proper impact assessment to analyze actually what could be done and how we could improve the situation, and we estimated actually both the cost and benefits for all stakeholders that are due to these dangerous products on the market. And actually we realized that, I mean, first on the side of consumers and society, the detriment was extremely huge because our studies found that the detriment that actually it's linked to the fact that, for example, the premature deaths or injuries that are linked to dangerous products that could be prevented if the products were safe, amounts to up to more than 11 billion euro per year. Also, the value of the dangerous products that are circulating has been estimated to more than 19 billion euro. So indeed, the detriment is very huge, and the new rules that are in the new regulation are here to aim to reduce this consumer detriment and detriment for society, and we expect to reduce them by 1 billion already this year, when the first year of application of the new rules, and over 5.5 billion over the next 10 years. Of course, for this, I mean, the current directive also, the previous situation, we write that it has also some cost for businesses because it was a directive, so the rules were not exactly the same across the EU, so businesses were facing not fully harmonized set of rules, and this was also creating some more cost. So indeed, the new rules had to improve also this situation. So what we did, what were our objectives? So I would say the main objectives of the new regulation are very here to improve, on the one hand, the consumer protection, but also to improve the level playing field between businesses. It's an important piece of the single market regulation legislation. So we really tried to add on these two aspects. We are not starting from nowhere, as I mentioned. We already had in place the General Product Safety Directive, which were basically here for more than 20 years, which were setting already the General Product Safety requirement. So the new regulation actually is here to better harmonize the rules, to have actually one single set of rules for the whole EU, so that you can so that businesses do not face different obligations, but they have indeed one set of rules. And also more specifically what we did. So we kept the what we call the safety net function of the current of the previous directive, which is that actually because the rules says that all products must be safe on the market, and and then actually it covers all the products that are not covered by other union legislation, or risks that are not covered anywhere else. And also we brought some novelties, because indeed, as you know, the market changing, business models are changing, and if we want to ensure that the consumer products are safe in every occasion, we need to have clear rules that also are more future-proof and tackling all the different sales channels. So we wanted to take into account the digitalization of the economy. So we have now actually we ensuring the objective was to ensure the same level of consumer protection in terms of product safety, both online and offline, and also to improve the market surveillance of of our rules. So because the enforcement is done by member states, and we wanted really to have a strong and harmonized set of rules, and improve also the rules on the product recalls of dangerous products, and also to improve the safety. Indeed, we have also we wanted also to ensure that the precautionary principle is well applied by all stakeholders. So this was with the modernization of the directive, and as I said, we started already the first reflection in 2020. The Commission proposal actually came and was published in June 21. Then we had actually 2 years about this discussion and negotiation with the Council and Parliament. We agreed on the final text, and the text that now is in an application actually already entered into force in June 23. And then actually between the June 23 until December, the 13th December 2024, when the text started to apply, indeed there was this 18 months period, which indeed was a specific purpose, because it's a very what we call the transition period. And so it means that these 18 months were here to allow to all stakeholders, be businesses, authorities, and others, to prepare for the application of the new rules. So indeed, it's to ensure the proportionality, to give also businesses sufficient time to get prepared to these rules. So now the text apply as of last December, so 13 December, and that's why also that we are here to explain into more details all the specific rules.
Good morning, everyone. Also from my side, colleagues. Let's continue now digging more into the substance of our presentation. So when looking at the subject and the scope of the GPSR, it's very important to stress and underline that we are covering all, targeting all businesses which are directing their activities to e-consumers. So that's something which is important to stress, that the scope of the GPSR is not linked to the establishment of a business in the European Union, but on the other hand, it is what decides is whether they target EU consumers. And when the business targets EU consumers, they are subject by the rules of the General Product Safety Regulation. Another important point, which Christina already mentioned, is about the fact that we are covering both online and offline sales in the GPSR, and there are similar requirements for both cases. So again, we moved from the strictly speaking brick and mortar shops, and also from the strictly speaking physical products, to a much wider scope in the interest of EU product safety. The GPSR applies, if you go back for 1 minute for the previous slide, so the GPSR applies to products which are placed or made available on the EU market. And what is very important to distinguish is that we have two main types of EU product safety legislation in the European Union. One of them, which is adding specific health and safety requirements for a specific type of consumer products or specific issues. This is what we call the Union harmonization legislation. And the other big part, which is one we are presenting for you today, is the general product safety requirements. So it's very important to stress that the GPSR is really working as a safety net. So we are complementing the union harmonization legislation. How does that work? It works in a way that the GPSR applies to products for which there are no specific safety provisions provided in other EU legislation. And it also applies to products where there are such requirements, but there are risks or aspects which are not covered by the union harmonization legislation. So this allows you to see that the GPSR really complements union harmonization legislation and provides for a coherent framework for all products that are offered in the EU market. And very importantly, also, when we talk about what kind of hazards or what kind of risks which we are looking at, of course, we are always looking at safety aspects. Nevertheless, we don't stop again at physical harm. So the GPSR is very clearly underlying now the principle that when we are understanding the health and safety of consumers, this comprises also mental hazards and mental health risks, ensuring that consumers are safe. So now if you go for the next lab, just to give you a couple examples of the products we are covering. As I mentioned to you that contrary to union harmonization legislation, the GPSR is not focusing on one type of product. On the contrary, we are covering really a wide range of consumer products, starting from very, let's say, simple products to new technology products as well. We are also covering new products, so basically the products which are put for the first place on the EU markets, but similarly, we are also covering second-hand products under the GPSR. And we are covering also reconditioned and refurbished products, which are very important for the circular economy. Very importantly also, we are covering in the GPSR products which are offered for consumers for remuneration. So the ones which consumers typically buy or order on online or offline stores. But we are also covering free products, so-called free products, which are offered, for example, for consumers as a sample or as a kind of present to make, for example, a subscription. So what is very important to say that all of these products need to be safe. That's really the general principle of the General Product Safety Regulation. So if we make just a short pause on new technology products, here it's very important to stress again, as I mentioned, that now in the GPSR, we are covering a wide range of aspects, and we are integrated new technology products fully into the general principles of the GPSR. It means, for example, that also a software, which can be looked as a product under the very wide definition of the GPSR, needs to ensure that it is safe when it's placed on EU market. We have integrated all the specific elements of these new technology products into the risk assessment grid of the GPSR. So for example, when a manufacturer develops new technology products, it has to think of how this product might interact with other consumer products and how this interaction might influence the risks. It also have to ensure that there are specific and sufficient cybersecurity features in place so that third parties cannot manipulate a product and pose risk for the safety of consumers. Or, for example, it also have to take into account the evolving and self-learning capacities of a product. So that's again something which is important to stress, that when you as a business design a product, you need to make sure that you take into account all these relevant aspects to ensure that the product is safe. On the other hand, what we are not covering in the GPSR in terms of products are typically products which have their own regulatory framework and which are covered fully by this regulatory framework. So just to give you a couple examples, of course, we are not covering food products, we are not covering plant production products, or we are also not covering transport services as such, or antiques. So these are products which are generally excluded from the application of the General Product Safety Regulation, and you can find the exact list in Article 2 of the GPSR. So it's also very important to mention, and I'm sure that you as businesses understood it very well, that the General Product Safety Regulation is a very important part of the EU legislative toolbox. when it comes to sales of products, when it comes to market surveillance, or when it comes to online sales or e-commerce. So that's important to mention, that the GPSR should not be looked in isolation. We are having very strong links to other initiatives. As the GPSR is building on the horizontal requirements of the Digital Services Act, we are looked as the specific legislation when it comes to product safety. And for example, in this case, in Chapter 4 of the GPSR, we have specific requirements introduced for providers of online marketplaces. In other cases, on the other hand, and more linking to the safety net feature of the GPSR, we are providing more the horizontal rules which complement specific EU legislation. This is very much the case when we see how the GPSR is interlinked to the AI Act. And very important to stress also that the GPSR is looking at responsibilities of businesses. So we see, you will understand it throughout the presentation, of what you have to do as preventative measures to make sure that your products are safe, but we also look what you had to do to make sure if there are issues arising, how to remedy the situation. Nevertheless, the GPSR as such is not touching on liability rules. The liability rules are covered by the product liability framework of the European Union. So very specifically, again, just still on this point of interaction. So when we look at how the GPSR is interacting with the specific rules of the Union harmonization legislation, which I just explained, that these are specific product safety rules or for specific categories of products or issues. To make sure that there is a clarity on how this interaction happens, Article 2 of the GPSR now provides a clear rule on what is to be applied for union harmonization products and what not. So if we focus on what is applicable to harmonized products, these are the general provisions, and these are also the specific obligations of economic operators on accident reporting and distance sales. And the reason for this is that there are no similar obligations in the harmonized product safety legislation. Moving a bit further, we see also that the Chapter 4 of the GPSR, which is the specific obligations of online marketplaces, would be equally applicable for GPSR products, but also for so-called harmonized products. It would mean that providers of online marketplaces need to respect these obligations in case any of the consumer products they are offering on their interfaces. Similarly, also the Safety Gate Rapid Alert System rules and the Safety Business Gateway is applicable for all types of consumer products. And also Chapter 8, which is on the right of information and remedy and product recalls, would be also relevant for all types of consumer products. We will go into detail on this more in the presentation. And in general, on the Chapter 2, which is basically the general safety requirement, and also this kind of general risk assessment aspects, we would apply for the risks not covered already by EU harmonized legislation, very much linked to the general principle of interaction I explained you just a bit before.
Thank you very much. So now we will go to the very specific part, explaining you the obligation for businesses in the new regulation. And so first, what is important? I mean that indeed the new general practice safety regulation explains the rule according to the different type of business and business model that you have. So first, what you need to do is really to have a look at the role that you are playing for a given product. So indeed, all GPSR actually concerns, I would say, all the businesses and all businesses that are somehow handling, offering, producing, distributing, whatever the product. So you have to see, and your role will depend really on what you are doing for a given product. Again, one company can also handle different products, of course, and so you have to analyze what is your role for a specific product, because for some product you can be, for example, manufacturer, and for another one you can be, for example, just a distributor. So you can have really different roles, and it's important to understand that. I can give you also a kind of telling example that in particular, for example, the online marketplaces, they are, of course, they are on their interfaces, they are offering a lot of products, and indeed on some products they can be just the pure intermediaries, and in this case they will be subject only to the obligations for providers of online marketplace in the GPSR. If they provide for a given product a fulfillment service, then they are subject to the obligation of economic operators because they become a fulfillment service provider for this product. If they have a distribution role and own the product, then they become the distributor and have distributor obligations. And ultimately, if an online marketplace decides to offer to consumers a product that is branded under its own name, then it will become a manufacturer. So this is very important to understand, and you analyze actually for every product that you are offering or handling, that what is exactly your role for this product, and then you can find a specific obligation in the GPSR that are reflecting this role. Indeed, because this was the purpose. We really wanted that the obligation in the GPSR are fully reflecting the role of the businesses in the supply chain. So I would say the responsibilities are tailor-made to the role that you are having. If you can just go back to the previous slide still again, and another point which is important is that we don't have any differentiated rules according to the size of the company. So because I mean the principle is that all products must be safe on the EU market, and so that's why indeed all companies are subject to the same rules to ensure that we have products that are safe, and it's also important, I would say, for the businesses, because it means that the consumers can equally trust small businesses as well as big businesses. So it's important that indeed consumers can trust in the same way everybody, which indeed then benefits also to the growth of all companies, including the small ones. So now when we speak about the obligation, so what we see, and we can go to the next slide, we have the actually two types, I would say, of obligations in the GPSR. On one hand, we have the obligation that are designed to prevent appearance of dangerous products on the market. This type of obligation relates to the fact that manufacturer needs to design safe product, that you have to do a risk assessment, have safety of information, etc. And we will detail this in obligation further on. And on the other hand, we have also another type of obligation that are linked to not to tackle the situation when it still happens, then a dangerous product arrives on the EU market. So that indeed are linked to the fact that how to correct the situation and to make sure that the dangerous product can be quickly taken out of consumer hands. And so now we will go in more details through this type of obligation. I will pass the floor to my colleague.
Thank you very much, Christina and András, and good morning, everybody. I hope you can hear me fine. So I will keep going with the novelties introduced by the GPSR. And as already mentioned by Christina, the regulation sets clear obligations for all the economic operators in the supply chain. So in the GPSR, we can find specific product safety obligations per type of economic operators according to their role in the chain. We have the manufacturers, of course, authorized representative, importers, distributors, and fulfillment service providers. And in that sense, the GPSR aligns with harmonization legislation, which is also organized around obligations per group of economic operators. And this was not the case under the directive. The GPSR also introduces new tasks and reinforces existing tasks for economic operators, notably regarding accident reporting and complaint handling, but we'll come back to this in a minute. Now, if we can go to the next slide, please. Zooming in for a moment on the manufacturer. The GPSR defines manufacturer as the operator who manufactures a product or has a product designed or manufactured and place places that product on the market under its name or trademark. Can I maybe ask my colleagues to mute themselves, please, because we hear a lot of background noise. Thank you. But also the person who places the product on the market under its name or trademark. So it means that, for instance, white labeling, rebranding, or adding one's trademark onto a product would qualify an economic operator as a manufacturer. Then another important point is the so-called substantial modification. And if a modification to a product affects the original safety of that product, and that modification may be physical or digital, the entity and the operator who makes that change to the product becomes responsible as the manufacturer of the product. And this might notably be the case for certain circular business models, for instance, remanufacturing or refurbishing, which is to be assessed on a case-by-case basis. Can we go to the next slide? Thank you. So the backbone of the regulation, but that was also already the case for the directive, really is that products being placed or made available on the EU market must be safe. And this is what we call the general safety requirement. It was already mentioned by my colleagues before. And manufacturers really have a crucial role for that purpose. So in practice, how do manufacturers ensure that their products are safe? Well, for each product, and we insist on each product, manufacturers must perform an internal risk analysis where they assess which risks their products can pose. Manufacturers also have to prepare technical documentation for each product containing a general description of the product and its essential characteristics, but I will come back to this in a minute. And it should also contain all of the identified risks and the measures put in place to mitigate or even better eliminate these risks. Importers must keep a copy of that internal documentation, and it forms a very efficient tool for market surveillance authorities to check whether the general product safety requirement is complied with. Next slide, please. Now, when it comes more specifically to the risk analysis, it's important to first set when is a product considered safe. Well, when under normal or reasonably foreseeable conditions of use, a product does not present any risk or only the acceptable minimum risk compatible with the product's use, thereby consistent with a high level of protection for the health and safety of consumers. So this is when we consider that the product is safe. And several aspects should necessarily be considered when assessing the safety of product. So this is notably the case for the characteristics and the presentation of the product. Does it contain safety warnings? Its appearance, for instance, food imitating products like the candle that you can see, the cake-looking candle, it has a food imitating feature which should also be taken into account in the risk assessments. The risks that are posed to certain types of consumers, for instance, if it has child appealing features. So the target consumers need to be taken into account. What also needs to be considered is the effect that the product may have on other products, as well as the product's potential evolving nature. Next slide, please. And this risk analysis feeds in the technical documentation because all of the risks identified in the risk analysis must be described in the technical documentation, as well as the mitigating, and again, even better, the eliminating measure must also be put in the technical documentations, as well as the relevant standards. And regarding the technical documentation, if we can go to the next slide, you can see here a model template for the technical documentation. And it's important to highlight that technical documentation is not a declaration of conformity, as might be required, for instance, for under some harmonization legislation. But under the GPSR, the technical documentation really must contain the elements that are directly linked to product safety. So, for instance, the product identification, the name of the product, the batch number, a picture, the characteristics and compositions of a product. What does the product contain? And then, of course, the risk analysis, as I was just mentioning, so a description of the potential risks and the measures that were put in place vis-a-vis these risks. And this is where also you should mention the use of technical standards. And while it's not possible to provide a template for each specific type of products covered by the GPSR due to its very wide scope and safety net function, this model template that you can see here on the slide forms a great basis and can be applied across all sectors. Next slide, please. Yes, and then another important point is that the GPSR, just like the directive before it, relies on technical standards. So standards are really there to help you with compliance with the general safety requirements. They're not and are never mandatory, so they're never legally binding, but they're very helpful in the sense that if you rely on relevant technical standards when developing or designing a product, you may enjoy what we call a presumption of conformity with the general safety requirements. So standards really are there to help you ensure that your products are safe. Standards are based on the state of the art, and they're regularly updated and published in what we call the official journal of the European Union. So you can find a list of the reference of these standards on our website. And also at the end of this presentation, we have added the link to these standards. And under the GPSR, there are several standards, notably for childcare articles, furniture, gymnastic equipments, and so onward. So complying with standards is not enough to exempt you for the obligations under the regulation, but really are there to help you with the general safety requirements. You may and might actually include them in your technical documentation, as I was mentioning before, regarding the measures put in place to mitigate and eliminate the risk associated to certain products. So now I will give back the floor to my colleague to continue with the presentation. Thank you very much.
Thank you very much, Marie. I will now speak about a very important obligation that is in the GPSR, because it's about the responsible person in the EU. As you know, more and more products actually are coming from outside the EU to our European market, and indeed for us it's important to ensure that consumers and national authorities, that they can have indeed somebody who is established in the EU that can help, maybe I would say, first of all, as a contact point, but also has some responsibilities that are linked to the product in case that also something needs to be done. This is not I would say it's not a new concept. It has not been established by the GPSR itself. This obligation already exists in the market surveillance regulation, and so which has been adopted in 2019, and established this obligation for several categories of harmonized products. The GPSR actually extends this obligation to all products it covers. So it means all non-harmonized products. So now actually the principle is that a product cannot be placed on the EU market if there is not a responsible person established in the EU for this given product. And who can be this responsible person? Here, the GPSR again follows the logic of the market surveillance regulation, and follows, I would say, this possibility in the form of cascade that you can also see on the slide. So, of course, if the manufacturer is established in the EU, it will be the manufacturer. If the manufacturer is not established in the EU, then it will be importer if it's established in the EU. Manufacturer can also appoint by a written mandate the authorized representative to take the role of the responsible person but this needs to be done on the written mandate. And here I would like to insist that indeed that not to confuse the authorized representative and the responsible person, because the authorized representative can be actually also responsible for other obligation of the manufacturers, for example, but it's really somebody who has the written mandate to do so. And authorized representative has also some specific obligations in the EU legislation. And if there is none of these three, so there is no manufacturer in the EU, there is no importer in the EU, and there is no appointed authorized representative by written mandate of the manufacturer, then if there is a fulfillment service provider, it will become the responsible person in the EU. So the appointment of the fulfillment service provider is automatic. So now what we can explain into more details, indeed, as we said, who is this responsible person? Definitely the EU legislation wants this, I would say, this responsible person to be meaningful, to have a role to play. As I said, it needs to be here for both for consumers and also for market surveillance authorities to provide different type of information and to take action if something is happening. So here the GPSR actually builds up on what is already in the market surveillance regulation. So actually the responsible person has first of all the roles that and tasks which are linked to the fact that it has to verify that the technical documentation that my colleague was mentioning before has been well drawn up by the manufacturer, and also ensuring that if the national authorities are requesting to see this technical documentation, that it can be made available to them. Then he has to provide information and different documentation that demonstrate that the product is safe upon the request of the authorities. If this responsible person learns that the product that he's responsible for is dangerous, then he has the obligation to inform the authorities about it. And also, it has to cooperate duly with the authorities. So, for example, the authorities can request the responsible person to ensure that a corrective action, for example, a product of a dangerous product, the recall of a dangerous product is properly done. So it's I would say, quite active role in this case as well. The GPSR added two additional obligations to that I would say specifically linked to product safety. So now under the GPSR, the responsible person also needs to do some regular compliance check that are linked to safety. So first of all, so regularly it is to verify that the product that it's responsible for are compliant with the technical documentation. That indeed then the risk assessment has been done, that that for example it complies with the standard if the technical documentation says that. And they also have to regularly check that the product has a correct labeling information and all the safety information and instruction that are required under the GPSR. So, for example, that indeed the product is labeled correctly, the name of the manufacturer, etc. So it's an important role, and I would say that we consider that this is also very important to also ensure the level playing field for all the businesses that are targeting EU consumers. So to make sure that actually all businesses are subject to the same rules, and I would say irrespectively if the product is produced here in the EU or outside the EU, we have the same rules because we want to ensure the safety of the consumer of consumers on our market. So we go to the next slide. So here there are also important obligation of what needs to be displayed as information on the product. The GPSR, as you see, it's a very product safety legislation. So all the obligations that we have here and information that we require in the new regulation to be displayed, be it on the product or its offer on the online sales, it's linked to safety because it means that it needs to ensure that we have somebody to contact in case of issue, that we can trace the product, that we can identify the product. So so all this is linked to this to ensure that the system works actually. So on the physical product, here it's I would say the same type of information that is required as usually in other EU legislation. So every product needs to have a good identification. So for example, the type of product, its serial number or batch number. I would say anything that allows a clear product identification. It can be also a barcode, but it's not mandatory barcode. You have to indicate the contact details of the manufacturer. So we need to know who is the manufacturer and its contact details, which are both postal and electronic address. When speaking about the electronic address, I will precise because it's also a question that sometimes we have received. Electronic address, it's something, actually the purpose is that that consumers can contact you directly. It means that it can be, for example, an email, but not necessarily. It can be also, I would say, a direct contact form on a website, but it needs to be really a form that it's easily accessible and then consumer can directly contact you. So it's not just a static website. It would not be sufficient for this purpose. Then if there is an importer for the product, again, he needs to be identified on the product with his name and also his contact details. If indeed the responsible person for the product that are coming from outside the EU, we always have to have the indication of who is the responsible person. It's on top of the manufacturer in this case. So if the manufacturer is outside the EU, you will have to indicate the manufacturer with the address outside the EU, and also then the responsible person who is established in the EU, which is to contact details and address in the EU. And finally, also the clear instructions and the safety information in a language that can be understandable by the consumer that you are targeting in the EU. Of course, we know that some products can be extremely small, so the GPSR allows that if the product actually, if the size doesn't allow of the product, doesn't allow to put all this information on the product itself, then it can be on the packaging or another accompanying document. But I would say the criterion, really the size is the only exception that we can accept, that this information is not on the product itself. This is also explained in the blue guide, which tackles explain in more detail the EU rules regarding products on the EU market. And as we mentioned in the beginning, I mean, as objective of the GPSR was really to ensure the same level of safety, both in the offline sales, so in the brick and mortar shops, but also in the online and other type of distance sales. Here also the traceability information is important, that we establish that it should be the same also in the distance sale. So actually the consumer can access the same information if the product is, if it goes and buy the product in the in the brick and mortar shop, or if, for example, it wants to buy it on an online marketplace or in the web shop of another company. So indeed here, I mean, in the second column, you can see actually the obligation that are now to have for every product listing in the distance sale. So again, we expect that every product which is offered in particular online, it applies also for a harmonized product, this provision, that you have to have a good product identification, you have to have identification of the manufacturer, of the responsible person in the EU, and also indication of any warning or safety information that needs to be that usually needs to be with the product in the offline sale, that needs to be also in the case of distance sale. This is very important, and we saw this some very good examples around on the market, and we really encourage you to provide this information, because this is very important to ensure that the product safety of the product. So if you go ahead, now when I spoke now about the labeling, one question which can of course arise, in particular, if some of the information that I have just now explained can be provided only in the digital format. The reply is clear: is no. Under the GPSR, you have to the information that is required to be on the product itself, on the physical product, needs to be spelled out there. It cannot be just a QR code directing the consumer somewhere else. It's of course, it doesn't prevent that you can use a QR code for adding additional information you want to add. For example, other type of information, for example, how to dispose for example, the product, or other, I would say, type of information or commercial purpose. Of course, all these businesses are completely free, but the information which was on the previous slide on the product identification of the manufacturer, importer, responsible person, and the safety information instruction needs to be spelled out in full terms on the product and as explained, and not only in a digital format. So now we can move to other type of application. So the GPSR also looked very much into the fact how we can get the information about accidents, because of course, some dangerous products can create accidents, and of course other safety issues, and it's important actually that we become aware of it. Actually, who needs to become? First of all, the manufacturer, because if the manufacturer receives the information about that an accident happened in the product, it doesn't mean necessarily that the product is dangerous, but already if for example, some accidents can start to repeat, etc. It gives indications, I would say, good information to manufacturer to think about, maybe to adapt the product, to redesign, or to adapt the instructions. So it's a very useful information for the manufacturer to ensure that its products are safe and to take appropriate actions. And of course, it's also important for the market surveillance authorities to see what's happening on the market, and maybe to looking at some categories of product that if some accidents are happening. So what type of accident here we speak about? I would say it's kind of serious accident. So it can be something that when the use of product results either in death or serious adverse effects on health and safety of a person. So it can be injuries or other damages of the body, illness and chronic health effects, and it can be something that it's either temporary, that can be solved, or indeed something which can be permanent. Actually, the important what is here to say, it's not a proactive. Actually, it's not a proactive obligation. So the GPSR doesn't require the businesses to go and search for information, not at all. Actually, here the principle is report the accidents and safety issues, and as soon as you become aware of them. And indeed, who must report? So first of all, the manufacturer. So manufacturer, if they become aware about the accident, they have to report it to the authorities. The importers and distributors, if they become aware, because indeed in many cases, for example, consumers may be more willing to go first, for example, to the distributors, for example, they bought the product, to tell, hey, look, I had an accident with this product and something is going wrong here. So in this case, the importers and distributors, they have to inform the manufacturer, and the manufacturer needs to notify the authorities or instruct the importer or distributor to do and notify this accident on their behalf. If the manufacturer is not in the EU, then it will be the responsible person who takes the role to and the obligation to inform the authorities about the accident. And how to report the accident, and I would say, and any other safety issue that you learn about. It's for businesses, meaning there is already a tool which has been existing and that we have now again improved. It's just called Safety Business Gateway. We will provide you at the end of the presentation with specific links. It's a tool where you, when indeed it allows you in a kind of easy way and structured way to report the accident and safety issues. And indeed, the GPSR makes this tool mandatory. So for everything you need to inform the authorities, businesses, you have to use the Safety Business Gateway like this. Indeed, the information is kind of collected and structured and transmitted in a structured way, which is very helpful for everybody, and also for ensuring that the information about dangerous products is circulating to authorities quickly. You can go to the next slide, please. Yes, so among the other obligations for economic operators, here we have, so indeed, when we speak about economic operators, so it's all the manufacturers, distributors, importers, fulfillment service providers. what the GPSR setup that requires to make sure that you have internal processes in place to ensure product safety. The GPSR is not, I would say, it's not prescriptive exactly what you need to do, because of course, you know, we also need to, I mean, to let business to organize themselves depending on the business model that you are doing and how we are organized. But what is actually important here is that you have a system in place that takes into account that indeed the product safety is well handled in your company. So some examples of what can you do is, of course, you can have some organizational procedures, for example, to know, okay, if I know that the product is dangerous, what needs to be done, who will do it, etc. Some internal guidelines. You can, of course, apply some specific standards, some ISO standards also. You can also appoint a specific, for example, ad hoc product safety manager who will be, and I'm sure that there are some of them are here listening to us already today. So somebody who is, you know, who is aware about the product safety rules and who knows how to apply them and who ensure that the companies, I would say, is up to date and ensure that all the processes are here to ensure that only products are safe and what you are handling, and if something happens that you can react appropriately. And finally, also what is important that of course the consumers, as you know, they have all the products. I mean, many of the businesses even sometimes do not open the product, obviously, in particular for example online marketplaces and intermediaries. So I mean, for us it was very important to actually to put, I would say, the consumers at the heart also of the GPSR in a way that indeed they are receiving the product. So they are really very likely to see the issues, the product safety issue directly by themselves, because they will notice they are using the product and it's important for us that they actually, I would say, to encourage them to report the product back to the manufacturer and authorities, and for this. It's important that you have that consumers that they can find the good, I would say, communication channels, how to report the accidents and different safety issues that they can observe with the product that they bought. So here, so what we expect is that manufacturers and importers, they have a specific channels how the consumers can submit complaints to you, and that so that you provide from a specific telephone number or electronic address or dedicated section of your website, and it's not only that you will collect this, I would say, this information and complaints, but also that you will, of course, take this information seriously into account and investigate these complaints and see see, you know, if there is really an issue. And I would say and I would say, first of all, don't just, you know, if somebody tells you, for example, say, okay, I would like to return a product because I had an accident with that, or I suspect, for example, something a safety issue with this product. Indeed, investigate it and contact also the authorities to see what can be done and how it can be corrected. But please don't sell it to anybody else, of course. So this is, I would say, take this information seriously into account, and for this complaint that you are receiving, indeed you have to keep them in the internal register as manufacturer and importer, and here also the GPSR precise that the person data cannot be kept longer than for 5 years. And for the next slide, yes. So we spoke a lot about the authorities. As you know, indeed, I mean, of course, the national market surveillance authorities, I would say, are the cornerstone of enforcement of the EU product safety rules. So the GPSR clearly established that all economic operators and also online marketplaces need to cooperate with authorities and help to eliminate and mitigate the risk. It's really important. So it's really your partners, and they are really working in a good spirit with businesses to make sure that to help them that indeed the dangerous products are taken off the market. And indeed, for this purpose, the market surveillance authorities in your member state, they can ask for different type of information to you. So just be prepared for that. So they can, of course, ask you for description of the risk of the product and how it has been eliminated. If you know about some complaints and accidents, I would say all the obligations that we explained before. Indeed, they can ask you the information. That's why also it's for you important to keep the record, to keep the technical documentation, etc. If you handle the dangerous products and the corrective, and if for example you decided to take corrective measures or voluntarily, they can ask you to describe what did you do to address the risk. And finally, they can also ask you who, I mean, because indeed, if a dangerous product has been found, for example, by one distributor, it's important for authorities to establish very quickly where the product, what is the supply chain of the product, where you can find other units, and it's important. And the market surveillance authority can ask you indeed the information about the supply chain, both up and down. So actually, who, for example, supplied you with the product or a part of, for example, a component of a product. It can be, for example, software that has been that you have included into your product, and then to whom also you have supplied the product, so that indeed we can trace the product across the supply chain. And how long this information needs to be kept. So we can go to the next slide, please. Yes, so indeed, here you can see that there are, I would say, two periods. So for 10 years, you need to keep the risk description of the product, related complaints that have been received, known accidents about the product, and any corrective measure that you would have taken. And for 6 years, economic operators need to keep information indeed about the supply chain. So information about the list of their suppliers and supply the part of the products or component and or the product itself, and information about to whom they have supplied the product. So it's important to keep this record so that indeed in case something happens and the product is dangerous, authorities can duly ensure that the corrective action is taken across the board by all involved companies. And indeed, now I'll pass the floor again to my colleague András to say what happens if indeed something is wrong with the product.
Thank you very much, Christina. And indeed, let's now focus on what do you as businesses have to do in case there is any safety issue arising with the product. So to look at this very simple but very clear, I would say, checklist, it's very important that you remember that you need to inform the consumers, and we will go into details on how you have to do this. You have to take also corrective measures to ensure that the product is not posing further safety risk for consumers. You need to inform also the market surveillance authorities of the member states in which the product has been made available. And Christina explained to you this on how to do such information. Of course, the use of the Safety Business Gateway is mandatory in this regard as well. And very importantly, you also need to inform the supply chain. So for example, if you are a distributor of a product, you need to inform the manufacturer on the safety issue that was coming across concerning the product you were selling. So going now into more detail on what to do in terms of product safety recalls, if you can go to the next slide. The GPSR had a very clear objective to making product safety recalls more effective. And for this, there is now a clear obligation in Article 35 of the GPSR for businesses to inform consumers about product safety recalls and product safety warnings. Why was this important? Because before the GPSR came into application, we came across with two main issues which were hindering the effectiveness of recalls. So first of all, consumers were not often aware of the recalls that were affecting them. And secondly, consumers were not reacting to the recalls on a way that it was ensuring their safety. So how did the GPSR address these two main concerns? On improving the awareness of consumers of recalls, now it's clear that there is a mandatory requirement for businesses to inform consumers about recalls, and they have to do it in different ways. First of all, there is a requirement to directly notify the consumers who bought the products, as long as you are aware of these consumers. Of course, that's more easy in case of online sales, where either the economic operator or the provider of online marketplace has a clear idea about who was buying the products. Nevertheless, to ensure even wider awareness on the recalls, there is also now a requirement to do a wide dissemination and a wide information campaign on recalls. For example, from online marketplaces now we are requiring to provide this information not only to the affected consumers, but also in a wider format on a specific section on their interfaces. And very importantly, that if you are using product registration schemes, you are also invited to use the information in these schemes in order to ensure that the recall information reaches the affected consumers. And how to make consumers more reactive to the recalls which are affecting them. First of all, there is now a requirement to use a clear recall notice template, which basically explains elements on how to action the recall notices. And US businesses also have to provide a right to remedy for consumers. So now if you look more in detail on what is contained in this recall notice template, it's very important to mention that the Commission adopted an implementing regulation on the product's recall template, which is setting out this template, which you can now also see on the slide. What is important is legally what is mandatory that you provide all the elements of this recall template when you have to adopt a recall notice, but the use of the template as such is not mandatory. We are really encouraging US businesses to use this template, because if you use this template, you can be sure that you provide all the required information for consumers. So just to look at the main elements, but these are also, of course, listed in the General Product Safety Regulation. You have to provide information on the company who is recalling the product. You also have to explain in the recall notice clearly what is the safety issue, why the product actually is dangerous. You also have to explain to consumers what to do as a follow-up of the recalls, or what to do as so-called precautions linked to the use of the product. You also very clearly have to indicate for the consumers what are the remedies available for them in link to the recall, and you also have to provide contact by which the consumers can reach you for further information and for further actions. So what is very important again, and it's important to stress that you are required to provide this recall notice in a written form, and you are required to provide all the elements of this recall notice template when adopting such recall notice. And if we go now to the remedies, it's also a very important point of the GPSR, and as we mentioned in the beginning of the presentation, this would apply to all types of consumer products. As a general rule, businesses who decided on a product safety recall have to offer consumers remedies, and they have to offer also the choice between the remedies for consumers. As a general rule, at least offering 2 types of remedies. And what are these potential remedies? These can include the adequate refund. So basically, when consumers' products are recalled, there has to be a way either to offer an adequate refund for consumers. There can be also an option to offer a repair of the product or a replacement of the product. But as I said, as a general rule, you need to offer at least the choice of 2 remedies for consumers. Now, if we go to a slightly different topic, in the beginning of the presentation, my colleague Christina explained that we are covering different types of businesses in the General Product Safety Regulation. As a main category, we are providing rules for economic operators, and on the other hand, we are providing rules for providers of online marketplaces. So Chapter 4 of the GPSR is the one which is containing specific product safety obligations for providers of online marketplaces. And if you look at this type of obligations, they are very much designed to cater for the intermediary function of these businesses. So important to stress that when we look at what we understand as provider of online marketplaces under the General Product Safety Regulation, we are understanding businesses which are intermediating the offers of third-party sellers and the consumers, and this intermediary function is the one which they provide as a service in relation to the products. So that's again, very important to stress that if an online business offers, for example, its own branded products, we would not consider them as providers of online marketplaces. In this case, they would be considered as manufacturer, and they would need to comply with the relevant economic operator obligations. Very similarly, if an online business offers fulfillment services linked to a product, again, they would be considered as an economic operator. So that's something which we need to explain very clearly, that one business is not always as a provider of online marketplaces or an economic operator. We need to focus on the specific services which are provided in relation to a product. And when we come to these specific safety obligations of providers of online marketplaces, of course, these are very much interlinked and are in coherence with the Digital Services Act. So as I mentioned to you in the beginning of the presentation, they are to be seen as specific rules on product safety, which are complementing the horizontal requirements of the Digital Services Act. So looking at what are the main obligations of providers of online marketplaces under the GPSR, there is an obligation to register in the SafetyGate portal and indicate the point of single contact for the market surveillance authorities. And that's something which is very important to stress, that now we have already the digital means to conclude with this registration. I will show you also at the end of the presentation the specific link. But for those providers of online marketplaces who target EU consumers, it's an obligation. And we are not confident that at the moment we have the full array of providers of online marketplaces already registered on the SafetyGate portal. So this is also a very strong invitation for those concerned to complete this registration process as soon as possible. When we look at the point of single contact, there are 2 points of single contacts mentioned in this regard. One would be for the market surveillance authorities. So this would be the one the authorities use to reach out to you in case, for example, they need to send you a takedown order, or there are other issues where there is a need to cooperate. And this is the one which you have to indicate on the SafetyGate portal for the authorities. And there is also another point of single contact expected from providers of online marketplaces, which would be for consumers. So that would allow the consumers to reach out to providers of online marketplaces. As a second obligation, there is also an obligation to put in place internal processes for product safety. And these processes are really to facilitate compliance with the GPSR obligation, and especially allowing you to follow up on takedown orders in a timely manner. And why is it important is that while orders are established under the Digital Services Act, in the GPSR for product safety orders, given their relevant importance, we introduced a strict deadline to action them within 2 working days at the latest. And in addition, if the market surveillance authority who is sending you these orders requires that in the future you ensure that similar product listings are not reappearing, that's also an additional obligation you will need to take, and you will need to ensure that these unsafe product listings are not reappearing on your platforms. Regarding third-party notices, so for example, notices sent by consumers or other interested parties, there is also a new deadline to process these notices within 3 working days at latest. If we continue on the main obligations, there is also an important point, and that's something which we receive a lot of questions on, about the interface design. So what the GPSR requires from providers of online marketplaces is to design their interface to ensure the display of minimum traceability and product safety information by the traders. What does it mean in concrete? It means that for each product listings, the online marketplace has to create the required fields of information, which would be similar to what we expect from e-shops under distance sales to provide. And also they have to ensure that the information is provided by the traders, and without providing such information on the listings should not appear for consumers. So that's an important point, that the obligation and the responsibility for the correctness of the information remains with the traders, Nevertheless, the online marketplaces are required to ensure that trader provided a certain amount of information in this regard. And what is required from the online marketplaces is to do the so-called ex post random checks. So on an ex post basis, they need to do random checks, verifying whether the information provided by the trader is correct. And for these random checks, when it comes to product safety, they need to rely also on the information published on the SafetyGate website. So for example, they would be able to trace whether the traders are not offering products which were already notified as dangerous in the SafetyGate in the context of this ex post random checks. The GPSR also requires to take measures against repeat offenders. So again, to ensure that traders are not repeatedly violating the rules of the General Product Safety Regulation. And there is also a very important requirement to cooperate with market surveillance authorities, cooperate with traders, or cooperate with other authorities when it comes to unsafe products. And here, an important point is about the recalls, which I already mentioned to you. So online marketplaces, when they become aware of a recall, they need to inform the consumer who bought via their interface the product. But in addition, they also need to make a wide information sharing activity to ensure that all potential consumers are aware of the recall. And in this context, also, when we come to the cooperation, providers of online marketplaces are also required to use the Safety Business Gateway to ensure that they communicate the information to the market surveillance authorities. And the GPSR also recognizes that these requirements are having a horizontal nature, so they are required for all the online marketplaces who are active in the EU market. Nevertheless, online businesses are very much encouraged also to go beyond the legal requirements via voluntary cooperation mechanisms, which are of course not legal obligation. One example here is the Product Safety Pledge Plus, where we have at the moment 11 online marketplaces who are signatories and who did take commitments that go beyond these horizontal obligations. But the GPSR also foresees the possibility to have other types of memorandum of understandings with online or offline businesses, or either at the Commission level or at national levels. So now, just to really recap all the information which we tried to pass together with my colleagues to you, we thought that it's very important to provide you with a short summary of what you need to know and what you need to remember from what you heard this morning. So as a recap of this, if you go to the next slide, it's very important again to stress that EU product safety rules apply to all products which are offered on EU markets and across all sales channels. So that's something which we really would like you to remember and to make sure that you keep in mind when you are offering products on the EU market. These can also cover products manufactured outside the EU and offered to EU consumers. EU rules would apply also in these cases. As a general rule, of course, all consumer products must be safe, and all specific product safety obligations shall apply to products placed on EU markets. Products which are coming from outside the EU and offered to EU consumers must have a responsible person. My colleague Christina explained you very detailed of who or what type of businesses could be considered as a responsible person. But it's very important that it has to be clear upfront who is the responsible person of this product, because the details of this responsible person have to be indicated in the physical product and had to be indicated also in the online listings or distance sale listings. And this responsible person, as Christina explained, has very specific tasks related to product safety. They have a cooperation obligation, and also they have to do regular compliance checks to ensure that the product is still the same which was described in the technical documentation. Again, for you as businesses, it's very important to know that if there are safety issues that you come across, you have obligations to action these safety issues. You have reporting obligations, and for this, you need to use the EU Safety Business Gateway to communicate with the authorities. You need to take corrective actions, and you need to also inform consumers and your business partners across the supply chain. So that's very, very important again to mention to you and to make sure that you don't forget. Especially, I would really stress the mandatory use of the EU Safety Business Gateway and the fact that you need to register with this EU Safety Business Gateway. And very importantly, again, as we set out in the presentation, every businesses, economic operators, or providers of online marketplaces have an important role for product safety. So that was the point and the objective of our presentation, to make you aware about your respective responsibilities. And you also have to understand that in case of non-compliance with these obligations, there are national proceedings, national market surveillance activities that you might be subject of, and they might result also in imposing penalties on you as businesses. But it's also very important to stress that respecting product safety and ensuring that you offer only safe products for your consumers is not only a question of compliance and question of avoiding penalties. It also is a very important tool to enhance consumer trust, and to also enhance trust in your business as such. So it's something that you can offer also as an engagement tool for consumers, and not only to be looked at as a formal compliance issue. And if you now look at where you can find more information on our presentation, of course, the most important most important source of information would be the SafetyGate portal. You will be able to see these links in detail, but here in the SafetyGate portal, there is a specific section on information for businesses, where we put all the available support materials, including the slides which we are using today. You will be able to find them there. You will also be able to find the recording of today's presentation, and you find also a lot of other materials, including a question and answer document which we developed. We also provided on this site the link to the relevant product safety legislation, including, of course, the General Product Safety Regulation and its summary. And also you can find the relevant technical standards. And if we go further, also in this information site, you can find how to get access to the Safety Business Gateway, where to register to be able to comply with your obligation to inform. If you are a provider of an online marketplace, you find also the link on where to complete the registration to the SafetyGate portal. And as I mentioned to you, this is also mandatory. So it's a really strong invitation for all the providers of online marketplaces active in Europe to complete this registration. In case you would need to get in touch with member states' market surveillance authorities on another issue which is not covered by the Safety Business Gateway, you can also find here the link which provides you with the main contacts of these authorities. And there would be also possibility, of course, for you to consult the alerts concerning the dangerous products which are published on the Safety Gate portal via the following links. And also, the last link is basically informing you that there is now a possibility also for consumers to raise safety issues to the market surveillance authorities. So this consumer safety gateway is not designed for businesses, but it's designed for consumers. And as a last point in this, and that's something which is also important to stress, that if you have specific questions on product safety rules in your national context, or if you want to make sure that you are compliant with the national requirements and how the GPSR is used and implemented in the national context, the first contact should be always the national market surveillance authorities. So from the Commission side, what we are doing is we are providing the general information on how the General Product Safety Regulation was constructed, what are the obligations for businesses, and this is what we are publishing on the SafetyGate portal. Nevertheless, if you have specific questions relating to your business and relating to your operation at national context, your main contact point should be the national market surveillance authorities. So that's why it's also important that you have now the contact list of these authorities, and you can address them with your specific questions. And I think by this we came to the end of our presentation. So I would thank for all your attention from our side on the slides.
Thank you very much, Andras, and my colleagues for this presentation, and also the replying different questions in the chat. So indeed, we saw that there are a lot of questions in the chat. Some of them have been replied there, and as we said in the beginning, also we will of course look at them indeed and feed our documents that you can find on the different pages that we indicated in the links at the end of the presentation, where you can find the frequent to ask questions. So definitely we will look at it. I will maybe just quickly, because we have still last 5 minutes, maybe to summarize some of the replies that I saw kind of appearing in the question. So question about how we enforce the rules, in particular for products coming from outside the EU. Definitely, as we said, enforcement is with national market surveillance authorities. The GPSR has aligned the market surveillance regime and to market surveillance regulation, and the authorities, they have strong powers to enforce the product safety rules. They are doing that, and that's why also it's important that any safety issue are properly reported to them via the Safety Business Gateway. At the Commission level, we are coordinating member states in the consumer safety network. So we are really trying to ensure that they can be as much as efficient as possible to have a good enforcement. And also we are doing a lot about the international cooperation, and you can learn about it all on our webpage. Regarding the traceability of products coming from outside the EU, again, this is something that we have explained, that there are respective responsibilities of every economic operator. So they have to ensure the manufacturer needs to put the information on the product, importer needs to verify that it's there, distributor needs to verify that it's there, and even on the online marketplace, as Andras explained, the product cannot be listed if the information is not provided by the trader in the listing. So actually the traceability really should be ensured for all products, even though those of course coming from outside the EU. On the question about the barcode, no, it's not mandatory. And what is mandatory is to have a sufficient clear identifier of the product, but of course you are free to organize yourself. Regarding the question on the risk assessment and the technical documentation, if it can be one file with several documents, yes, of course, it can be one file with several documents. Important is that all the elements that has been explained that needs to be in the technical documentation that are there. Regarding the accident, there was one question which indeed made me think that I need to precise something what I said about the accident reporting. Accident reporting needs to be done without undue delay. It means that when an accident happens, you learn about it, for example, as a manufacturer, you quickly check, okay, if it's a product related accident, it means that it's not something that really is completely that the product cannot be involved. But if there is indeed a possible suspicion that a product could be involved in causing this accident, you notify it via the Safety Business Gateway. And only then afterwards you start, I would say, the proper investigation with the risk assessment. Now, so at the end, of course, you can end up with saying that the product is dangerous or not, or the level is high or low. But I mean, the accident itself needs to be notified without undue delay. It means from the beginning. A lot of questions also about the B2B, B2C. I think Andras very well explained that. Indeed, we apply the rules to the B2C. We cover consumer products. We have actually a definition on consumer product in the GPSR. You can have a look. Actually, it's of course we exclude the pure professional products. But if there is a product that indeed it's possible to expect that consumers will enter into contact with the product, then it's covered. So it's quite wide definition. So for example, we are not covering services as such, but if there is a product which is provided that the consumer can access in the context of a service, then indeed it's covered. So have a look at the definition of the consumer product. It's wide enough. But indeed, there is always the element that we can expect that the product comes into contact with the consumer. And regarding the interlink with the harmonization legislation, we have explained indeed the GPSR really comes as a safety net. We have a specific slides on this in more details on our website, so you can have a look. And but indeed, what is clear that indeed for those that are covered by union harmonization legislation, some of the chapters do not apply. But what is clear that what applies always as a safety net is the chapter 2 with the general safety requirement and the need to do a risk assessment. So even, I mean, so for the for example, I mean, there was, I think, one question about, for example, textile, as there is no, I mean, indeed there is a textile legislation, but this textile legislation doesn't speak about product safety. It means that indeed the chapter 2 is fully applicable to textile products, and you need to ensure that the textile products are safe and that you do the risk assessment following and take into account all the aspects for the risk assessment that are established in the chapter 2 of the GPSR. And finally, on the safety information, there were questions about online. Indeed, the safety, I mean, with the physical products, the Article 9.7 of the GPSR says that indeed the product sometimes doesn't need to have in a safety information instruction if it can be ensure that the product can be used safely as intended by the manufacturer without such information. So again, it's an assessment on a case-by-case basis by the manufacturer. But of course, if the manufacturer establishes that there needs to be some safety information, for example, age limitation of the product or whatever, then it needs to be on the product as a physical format, and then it needs to be reflected in the online sales. So I think from my side, it was all. I don't know if some colleagues want to no, nothing comment. So I think it's fine. So with that, I think that we can close. We came to the end of the seminar. I think so we can close it now. I would really warmly thank to all of you for your participation, which was huge. We know that we reached the limit of the WebEx tool, so we could not have more than 1,000 participants. So if you know about people that could not attend this webinar, as we said, it has been recorded. We will post it on our web under the link that my colleague presented to you. The audio, find a lot of information. So very many thanks for your interest in product safety, and stay alert and stay informed, and look at our website if you need more information. Thank you very much to everybody, and have a lovely day. Goodbye.